Good afternoon. You can be seated. The matter before the court is BCD 25337, Friends of Eastern Bay versus the Department of Marine Resources. We are being streamed on the web, both by audio and by video. Before we begin the argument, I'd ask that counsel who are arguing please introduce yourselves by saying your names for the record, together with the party you represent.
David Callan for the appellants, Friends of Eastern Bay.
Assistant Attorney General Valerie Wright for the Maine Department of Marine Resources.
Thank you. And Attorney Callan, if you're ready to proceed, we're happy to hear your argument here this afternoon.
Good afternoon, Chief, and may it please the court. Friends of Eastern Bay is a membership corporation that includes as its members the Mount Desert Island Biological Laboratories and several individuals. Many of those individuals actually were the same individuals that were involved in the Uliano line of cases, which was a set of cases under the Natural Resources Protection Act involving the same stretch of the Eastern Bay. And the biolabs are actually discussed within those decisions as a way of locating where those took place. One of the central issues here is whether DMR exceeded its statutory authority in approving a floating storage dock that's used solely for the purpose of warehousing a piece of equipment when it's not in use. This is not a case where there's any deference to the agency because this is a set of overlapping statutes that involve multiple agencies, some of whom are not parties here, where the legislature has carved up the authority to lease subtitle lands and put that authority exclusively in one place or the other. So all subtitle lands are coastal wetlands within the state's statutes and statutory scheme, and for most uses, the decision about whether the state will grant property rights and become a landlord, lease a section of the ocean or the ocean floor, rests with the Submerged Lands Leasing Program within the Bureau of Parks and Lands. And because all submerged lands are coastal wetlands, almost every use, unless there's an exemption, requires a NRPA permit, Natural Resources Protection Act permit, from the DEP. An exception to both statutory schemes is aquaculture leasing. Under 12 MRS 6072, standard leases are exclusively within DMR's authority for the purpose of aquaculture leasing. And so that's what sets up this statutory scheme where it's an either-or situation and not a single agency administering a single statute where they might receive deference in interpreting ambiguities therein. The central issue here is whether, on the floating dock, is whether it is in fact aquaculture as the statutes define it as the husbandry of marine organisms, or whether it's ancillary thereto. We think that it's plainly ancillary thereto. A very easy way to think about that would be if there were two aquaculture sites and they were using this piece of harvesting equipment on both of them, and they wanted to store it halfway in between, and they wanted to put a floating dock there to just for that storage purpose. The question might be, would they apply for an aquaculture lease from DMR, or would they apply for a NRPA permit and a submerged land lease from PPL?
Let me ask you, because the green light is on. Are they mutually exclusive? In other words, can it be aquaculture that must be permitted by, as this was, but also still need potentially permitting under NRPA?
So that's the way that I understand the department to having briefed it. It's not, the court's never so held. The statute says DMR's authority in this realm is exclusive, and NRPA and the submerged lands leasing statutes exempt anything that's within DMR's authority. So the statutes seem to read like it's one or the other.
If we say that, yes, it is ancillary, it is really part of the aquaculture, and they could say it's okay, then that's the end of the question. It doesn't go to NRPA.
Well, what NRPA says is if it is ancillary, it's within NRPA. So the way the NRPA statute reads is it exempts aquaculture as permitted under 12 MRS 6072, so in DMR's exclusive authority, except, it says, things that are ancillary thereto
I said it,
are
I said
not
it
exempt.
backwards. I said it backwards. I
But-
apologize.
But yes, your point is well taken.
So, but you're suggesting that if it was okay for DMR to permit this as part of aquaculture, that ends the discussion, it doesn't go to NERPA?
Well, the NERPA question, if it is ancillary to aquaculture, it plainly requires a NERPA permit. Our position is that if it is ancillary, it is outside DMR's authority.
How
But
do you define ancillary?
Well, it's ancillary. A common dictionary definition of ancillary, since it's not defined in statute, is kind of secondary, subservient thereto. I think if you look at how aquaculture is defined, it's defined expressly as the culture and husbandry of the marine organisms. So if you're using it to grow the organisms, culture or husband them, then that is aquaculture by definition.
They are using it to husband them. They're using the harvesting machine to.
The harvesting machine in use is being used to harvest the organisms. They could store it on land. As they said, if they had a slightly larger boom crane, and they may now, they would have no problem loading it or unloading it. And they could store it on a dock that was outside of the lease.
So if the harvester, unlike the record in this case, if the plan was that we need to use the harvester every day, but then it would be okay to have it be on a raft?
That's certainly a closer question, yes. I mean, if it were in use every day, it probably wouldn't be on the raft. Most of the way that the equipment and the structures that get used, they're like the organisms are grown on gear that's attached to something, and the equipment that's all attached to that is used. But in a situation like this is a piece of equipment that's used 2 weeks a year, according to the testimony. And exactly which 2 weeks those are, there's a little dispute over. But the rest of the year, they're just storing it.
What if this were a finfish aquaculture operation, and they used the raft to store, I don't know, feed or nets or other things that you would use on a daily basis in that enterprise? Is that an ancillary use? Isn't it integral to the operation of the enterprise?
I would say on a situation like that, where they're storing something that's in use constantly, then that's pretty far removed from what we have here, which is that it's something that's used 2 weeks a year.
But your challenge is to the float itself, not to the machine on the float, right?
Right, the float and the purpose.
What's the difference between a float that supports a machine that's used periodically and a float that supports tools that are used on a more regular basis?
Sure. So under the submerged land leasing program, when the Parks and Lands is making a leasing decision, they have a set of criteria that's mostly about whether to become a landlord. And the regulatory component is with DEP. And it has very similar standards, whether things unreasonably interfere with certain environmental and other issues or uses in the area. And what the legislature has done with DMR is they've kind of combined the two, and they've said if it's the culture and husbandry of marine organisms, it's a narrower set of things that we're looking at. But when it's just the storage of that equipment, we think it's pretty clear if you line up the various exceptions to NERPA that that's the type of ancillary thing that they weren't trying to say is exclusively in DMR. For example, if the storage were just everybody's fishing gear, or sorry, their clothing, right? If it's like the clothing that they wear there, that they can get dressed before they show up, but
what is the level of time tolerance that you would accept? You pointed out that the harvesting machine is used only 2 or 3 weeks a year.
Yeah.
Is there a certain amount of time when the harvesting machine is inactive, sitting on the floating dock, that would still allow it to be considered as aquaculture? I mean,
Our contention is-
overnight should be fine, you would think.
Well, our contention is that it wouldn't be aquaculture. The storage of the equipment just isn't aquaculture. That just, if you've got a float where its only purpose is not to actually culture or grow or husband the organisms, but just stow your gear, our view is that's always ancillary no matter how much time it's being used for storage.
So even during that 2 or 3 week period when the harvesting machine is being used, the floating dock during that period of time is still not part of aquaculture?
So the way the harvesting machine works, it doesn't actually go on the dock when it's being used. It gets clipped to the equipment and it crawls up and down it. So that's, I think, what shows when it's being used as the husbandry of the organisms. It's when it's clipped to the rest of the equipment. Our view is they couldn't have a storage dock for any period of time.
So I guess maybe I misunderstood. I thought you said at the outset that if they were using the machine every day, it might be a closer question as to whether the storage raft was integral or ancillary. Now you're saying it's always going to be ancillary?
So I apologize if I misspoke. I think I was answering a theoretical question and not the specific. I think this harvester, when it's used in the way that is part of aquaculture, it clamps to the other equipment that's already there. It doesn't sit and get stored anywhere. So our view is this storage dock would require a NERPA permit, whether it's inside the lease area, outside the lease area, or halfway in between two different lease
Can I
areas.
go to the NERPA statute, though? Subsection 10, which is whatever it is, 480Q, says that aquaculture activities regulated by a DMR under Title 12, et cetera, are exempt. Ancillary activities are not exempt, but it uses as examples ancillary activities, not structures, not anything else, but activities, building or altering docks, filling of wetlands. There's no such activity going on here.
Well, first, I think there is filling of wetlands is a technical term under NERPA. All submerged lands are wetlands, and filling is broadly defined, anchoring things to the bottom, except for the exemption for moorings specifically.
But this is the exemption for aquaculture, is ancillary activities, including altering docks or filling of wetlands. That's what
Right.
they use as examples that would require NERPA intervention.
Right, and so if you look at farther up in that same section when it talks about the floating dock exception.
Yes.
So it says floating docks are exempt unless, only if they're replacing an existing floating dock. So what that tells us is they've said altering docks, building or altering docks is ancillary. I see my time's up.
Finish your sentence.
That building or altering docks is ancillary, and that a floating dock that's not replacing an existing floating dock is a whole new structure.
Thank you.
Chief Justice Stanfill, Associate Justices, may it please the court. DMR did not make a determination whether this is an ancillary activity, this raft to be used within this particular lease's boundaries is an ancillary activity or not under Title 38. The interveners seem to want DMR to make that call throughout the agency proceedings, and as we outlined in our brief, DMR repeatedly said, no, we're not making a determination about what Title 38 means. That's not our job. Our job is to apply our authority and do what we're supposed to do under Title 12 and determine whether this equipment that is being proposed for use in this lease, including this floating raft, meets the criteria that we have in Title 12 and in our rules, and so that's what they did, and that's what's under review to this court. The commissioner is absolutely authorized by Title 12 and by the associated rules that were approved by the legislature, because they were major substantive rules, to approve Acadia Aquafarm's use of a moored raft within the lease boundaries to store equipment used for aquaculture activities. Nothing in NERPA prevents the commissioner from duly exercising that authority under Title 12. On the noise issue, in concluding that the lease will not result in an unreasonable impact from noise, the commissioner relied on ample evidence in the record that the Acadia Aquafarm's mechanical equipment is designed to reduce noise to the maximum extent practical, and that the leaseholder is going to take all reasonable measures to mitigate any noise impacts from their activities in the lease. I think I'll just open it up to questions because I think
So-
you're ready to go.
My question is, having not made a decision.
Yes.
And they're taking the position that this isn't an exempt floating dock. Could they go to the DEP right now and start a proceeding saying that this needs a NERPA permit?
I think they could try that. Whether DEP would entertain that under their procedures, right now, I don't know.
But you said we made no decision, so it's not
Right.
a res judicata issue, right?
Correct. Oh, absolutely. Alternatively, once this operation is up and running, someone can go to DEP and say, hey, DEP, we need you to start an enforcement action. This operation is doing something that we think requires a permit.
Enforcement, it's a little more tricky if they try to get an enforcement going. Is there a mechanism where they can get an actual determination that can then get reviewed by a court?
Understood. That would be a question for DEP. I don't know the answer to that, but certainly from DMR's perspective, we're not saying they can't do that.
This was referred to DEP.
Yes.
Did DMR ever get a response?
No.
Is that typical? That you wouldn't get a response from a sister agency?
It is typical if they presumably have no concerns about the application. Sometimes they do get a response. Sometimes DMR, if they feel they really need a response in order to make certain factual findings, they'll nudge the agency and say, hey, we'd really like to hear from you on this. So it just depends.
When it was referred by DMR to DEP, was it characterized as a non-discharge permit?
I believe it was, because DMR makes that decision early on because the applicant has different responsibilities. If DMR, for instance, characterizes it as a discharge permit, the applicant then has to do extra things.
Based on more recent developments under federal law and, of course, under state law with respect to PFAS chemicals, on this record, would DMR consider this to be questionably a discharge permit?
Not on this record, no.
Why not?
Well, first of all, there's no evidence in this record that the equipment Acadia Aqua Farms will use contains PFAS. There's no evidence in the record that if it does contain PFAS, that its activities will result in a discharge of PFAS into the water. And then even beyond all of that, there's currently no standards in Maine for PFAS in discharge into waterways. So for instance, wastewater treatment plants are discharging treated water into waterways all the time. There's no standard for PFAS levels in that water. So I think for a lot of reasons.
Well, whether or not there's standards for it really doesn't have to do with whether it's a discharge application, does it?
I suppose that could be a different question, but I think it all goes to the fact that on this record and on the information that DMR has to date from DEP has never required any shellfish operation to have that.
If I understand this correctly, defines discharge as spilling, leaking, pumping, pouring, emptying, dumping, disposing of any pollutant. It sort of implies some sort of output. As I understand the argument here is that some of the equipment, when it's washed down, might have PFAS in them that will be exuded. So DMR has defined discharge fairly affirmatively regarding output, actual output. To what degree are we to give deference to DMR's definition of this critical term? Do we apply deference here because it's the agency interpreting or creating its own regulation?
Well, I think when this issue or a similar issue was raised in the Maquoketa Bay case, this court said that it did defer to the agency's determination of whether the application was a discharge application or a non-discharge application because it was a mixed question of law and fact. So I think the same is true here, and there's no evidence that an actual discharge of a pollutant is going to happen with the activities as AAF has proposed them and as the commissioner of DMR has approved. There's no evidence that PFAS will be discharged through this process of power washing this equipment.
So would you disagree with the argument that's been made that we don't give deference to the interpretation of the statute because there are two agencies that have authority in the same area?
Well, which statute, I guess, are you referring to? If you're talking about Title 38, DMR didn't interpret Title 38. DMR interpreted Title 12, and I would certainly argue that deference is accorded to DMR in interpreting Title 12.
And I think they made a very short and snappy Lopez-Bright argument, and you responded. Do you have anything to add to your response on that front?
I don't. I think, you all may need to get into that issue in depth in some case, but it's not this one because the other side didn't brief it. We said a bit more, and I don't think I need to say any more on it at this time.
Can we go back to the referral to DEP in the absence of a response? Can we infer anything from that about DEP's position on the application of NERPA in this case?
In the business and consumer docket, the judge asked a very similar question. And, I recognize that I think the application was directed to the water discharge folks at DEP, and perhaps not to the folks who handle the NERPA permits. So I'm sensitive to that. I think that you can certainly draw an inference that they were perfectly happy not to consider this as a discharge application. It's a little more difficult to draw that inference with respect to their silence on the NERPA issue. So I guess I would say at this point we don't have evidence on this record that question has been squarely presented to DEP.
And then I may be understanding Friend's argument, but I thought I understood Attorney Kalin to say that if we were to interpret the raft here as not being ancillary, then DMR would have exclusive jurisdiction, and so there'd be no need for a NERPA permit. Your position is that's not true. If we affirm this, they still could go to DEP and say, you actually have jurisdiction over this raft?
I think the only issue here, properly on appeal, is review of the decisions the decision that DMR made and the findings and conclusions that DMR reached. And DMR simply did not make any finding or conclusion with respect to that. So
it may matter if we were to say we agree, whether we actually tread further and said, and besides, it doesn't look like this, meets the definition of ancillary.
Right.
Or not.
I mean,
You're
right.
saying DMR didn't make that determination.
DMR didn't make that determination. So if and when DEP made some determination down the road, I don't know what would come of that because I don't know what the posture of that would be, and so that's just kind of speculative at this point. Sorry, I'd like to offer you more, but I feel like that's...
And you're saying it's not necessary for our decision to decide even whether it would otherwise be applicable.
I think that's right, because...
Does that make sense if we would tread such a small or fine line?
Well, I mean, all DMR can do is exercise the authority it has and undertake the duty it has to apply the criteria in its statute and its rules to this equipment. And I think that's just so clearly true here, where the equipment we're talking about is going to be used within the boundaries of the lease. It might get a little more complicated in other factual scenarios, perhaps, but in this scenario, it's within the boundaries of the lease.
And that's really actually very different than actually, building a dock on shore.
Oh, totally.
Or wetlands.
Totally. No, I think if someone were proposing to build a fixed dock or a floating dock, attaching the shore line to the lease area to facilitate access to the lease area, I
Or
think
even
that's
if it wasn't attached, just as we need to land here. To
yeah, I think that's a whole different story, and that's not what we have here.
What if it was attached, a floating dock, and what if it extended into the lease area? Suppose the lease area came within, let's say, 50 feet of the shore, and you had a long dock at the end of which was a floating dock. Doesn't DMR in that case have to make some sort of determination as to whether this is an ancillary activity?
I don't know if DMR has to be the one to make that determination, but I think that would certainly present a closer call as to whether or not DEP would be required to be involved in that situation.
In
But-
which we get back to what I was asking in the beginning, which is how do they get this in front of DEP? I mean, and if they just go and say, I'd like an enforcement action, and they do absolutely nothing, it's not appealable.
No, it isn't.
So
Right.
the question is, how do they get that in front of DEP, and should that matter in this case?
I think there are other ways that they could do that, and that they could perhaps seek some sort of, injunctive relief until this got worked out. But again, I mean, that's just not, we racked our brains to try to think of how this would come up with a piece of equipment that's just used within the lease boundaries. I agree with you. When it gets outside of the lease boundaries, it gets much more complicated. But that's not what we have here. We haven't had that situation come up, or at least not where there's been any sort of battle over it. So, but here it's a work raft. All of these leases, tons of them have work rafts and floats for various uses. Some of them the people will be working on, they'll have their oyster sorter and tumblers on them, and they'll be doing that on the raft. Some of them will be cleaning shellfish, they'll be sorting. This is working aquaculture. This is what it looks like. You have a lot of equipment involved, and some of it has to sit on something when it's being used or when it's at rest because the people are busy doing something else. That's what it looks like.
There don't appear to be additional questions.
Okay, thank you so much.
So that was my question to you. Why not just go to the DEP?
We have similarly racked our brains. We've tried very hard in this and other situations, and there isn't an easy answer to that question. We think that it is pretty clear that it is an either-or situation, that DMR can't say, we don't have to figure out whether this is exclusively with BPL or exclusively with us. We can just say it's with us, and if it's also with DEP,
But is there a mechanism that you can go to DEP and say, please look at this? It needs a NERPA permit?
I don't believe that there is one that Ms. Wright's office would not move to dismiss on a lack of standing ground. If we were an aquaculture entity, and maybe we could use the advisory ruling provisions of the APA and say, hey, if we wanted to do this, do we need, like, which permit do you need?
You would lack standing there, but not in this action?
Well, here we're interveners in an application that an applicant filed. There, DEP has no application. Nobody's voluntarily submitting to their jurisdiction.
No, but this is
that
a
gives us
real
to-
project. It's not like this is a theoretical project.
Right.
I can't remember the name of the case we had where it was sort of like there wasn't a project yet, so they were asking DEP for advice essentially on something that wasn't even
It's true. It's a real
immediate.
project, and it could be the subject of an enforcement action, but not one that we can trigger. One other issue that I do want to address just briefly is the other uses of the area issue, which is an important one. In the ocean, where DMR is making these decisions, we don't have the benefit of the tool of zoning because the legislature hasn't said incompatible uses can go over here and over here, but not right next to each other, the way that we can do on land. But what 6072 does in subsection 7A, subsection C, it has an other uses of the area catch-all. And in that circumstance, when there is a unique other use of the area, like the MDI biolabs.
I mean, did DMR essentially say land-based? We're not really talking about land-based uses, we're talking about water-based uses?
They do, and we believe that is a misreading of their statute.
But then the commissioner went on and made extensive findings about the effect that the project would have on MDI lab.
Well, no, they said they were doing that within the noise context, which is a different criteria. And as we've outlined in our reply brief, the noise requirements are much softer. If someone...
But it's still focused on, your issue is still focused on the noise.
Yes, we believe we win on the noise issue, on the narrower noise
But
issue.
I mean, whether it's under use or noise specifically, it's still focused on, in fact, the noise.
Yes, yes. The impact, the thing that makes it an unreasonable impact on the biolabs
use.
is how loud it is and how it interferes with these
Well, then, isn't
research.
that sort of exactly like McCoy Bay, where one thing was considered under one, but it really constitutes as well a decision under the other?
We don't think it's exactly like that, but it is your prerogative if you do.
Okay, thank you.
Thank you.
Counsel. As is our usual practice, we will take the matter under advisement, issuing a written decision in due course. And with that, we'll be on recess on this matter. You may be seated. And the matter before the court is VCD 25-166, Bruce MacMillan versus R.M. Davis. I see counsel are present, and I'm assuming ready to proceed. We are being streamed on the web, both by audio and video. I would ask counsel who are arguing in this matter to introduce themselves for the record and the party you represent, together with the appellant. I'm starting with the appellant.
Bruce Hepler for the appellant, Bruce MacMillan.
Susan Widener on behalf of R.M. Davis.
Thank you. And Attorney Hepler, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court, my name is Bruce Hepler. I'm here on behalf of Bruce MacMillan. There's a lot of facts in this case, and before I discuss and really delve into the arguments here, I want to tell a short story, and I promise you it's relevant. But a few weeks ago, I had to bail out a client. So I needed $10,000 of cash, and I went to Bank of America, where I have my accounts. Asked the teller to get $10,000, and he had a lot of questions for me. He took me to another teller. Ultimately, they took me to the manager of the bank. The manager of the bank sat with me, went through my accounts on the screen. He had a ton of questions, wanted to know what I was going to use the money for. Of course, I was being completely transparent, telling him, completely honest, what I had going on. He talked to me about fraud. He talked to me about scams. Evidently, there's some various construction scams that are going on lately. He was very thorough and asked me questions. Now, I do not have a fiduciary relationship with Bank of America. I am not 65 years old yet. This was just for a very small portion of what I have in the bank. Yet it was in absolute stark contrast to the facts of this case, where in the two short telephone conversations, R.M. Davis allowed their fiduciary, Bruce MacMillan and Linda MacMillan, to liquidate their accounts simply on 10-minute conversations. The second conversation, he didn't even ask questions of where the money was going to go. So R.M. Davis tries to argue that what we're asking for here is unworkable. That's absolutely false. It's absolutely incorrect. And it can be seen simply by seeing what Bank of America has done here. You can ask questions. You don't even actually need to know the client to be able to ask questions about the client and go through their account and see if this is a usual transaction or an unusual transaction, see whether it was expected, and to see if this is the kind of thing that's going on, and to be able to ask questions and listen to the answers, which is absolutely what did not happen in this case. Now, I recognize that this is a bit of a unique case, but it's also a unique case that a court has never decided that financial advisors don't have a duty to protect their client, as R.M. Davis is trying to argue. There hasn't been any courts that have said that financial investors do not have the duty to know their client, that they don't have a duty to protect their client. So this is an open question really here on both sides, but all the testimony in this case, all of the witnesses in this case certainly seem to think that they do have duties, fiduciary duties to know their client, fiduciary duties to try to prevent elder financial abuse, duties to try to stop elder financial abuse and figure out what's going on.
Well, I see the green light is on. I will say I'm a little disturbed that you started out with the story saying that you went to the bank to get money to bail out a client, which would be a little bit problematic, but.
Why's that?
Well, under the bar rules, I don't think you can bail a client, but putting that aside.
Well, it was his money. It was his money.
It's that's not the issue. Is there a dispute whether Carr advised Bruce MacMillan of the tax consequences that would result from the liquidation of the IRA? In other words, you seem to raise that as an issue, but I know that there's also record evidence that says that he did inform him, that there would be significant tax consequences. Are you disputing that is a fact?
No, that's the one thing that he did tell him. He didn't advise him not to do it.
Okay, so how do you have a claim based on that then?
Oh, easily, because he should have gone many steps further. Absolutely, he told them that there was tax consequences, but he didn't go and take it one step further, as the other witnesses have stated that he should do. That he should say, hey, this is directly contrary. This is antithetical to to what you've done for 15 years. It's antithetical to your account objectives.
So it's not a failure to advise about the tax consequences. I thought you were raising an argument that there was a failure to advise about the tax consequences.
No. I certainly haven't argued that, because he did tell them that there was going to be $330,000 or so of taxes. He did give some advice on that matter, but what he should have been doing, he should have been telling them not to do the transaction.
So where's the source of the duty there? The client comes in and says, I want to do this with my money, and the advisor advised about tax consequences, but the client is resolute, I want to do this. Why do you want to do it? It's a real estate deal, but I can't get into it. So where in the documentation with a fiduciary duty does it say that the advisor must say, whoa, hold on a second, client, I know you're competent, I know you're an adult, I know it's your money, but stop, you can't do that. Or you shouldn't do that.
Well, I don't know that he is competent. I mean, there is diminished capacity here. I mean, so I don't want to skip over that, but where is it? No, there's, I mean,
So the advisor was under notice that his client was diminished capacity?
Absolutely. There's been a ton of evidence in this case, testimony as to what is diminished capacity. And it meets all the red flags for diminished capacity. 1,000%, yes.
Okay,
He was
well, go
under
ahead
notice.
with your answer then. Where's the source of the duty to push back and say, no, Mr. Client, I'm not going to do this?
Sure. It's a number of places, but there's the fiduciary duty. It's from the courts and from the SEC that said it's a very broad and flexible fiduciary duty.
To give good advice. That's the duty. The scope of a financial advisor's duty is to give them a good advice for the person in that situation. Couldn't they get in trouble if they tried to put a hold on the transaction?
No. No,
You
not
think
not
that
if it was an indefinite hold, potentially, yes. But no, there certainly could be a day, 2 days.
Under what authority?
The testimony that we've got in this case is they absolutely...
Is there a statute? Is there something that says,
Well, there's not a
financial
statute.
advisor, you can, when you are instructed by your client to release the funds to do X, and you don't do it immediately, and it turns out it was, wow, you could have made a lot of money had he done it at the right time, they can't sue him?
There's standards in the industry on this very point.
There are immunity statutes under certain circumstances.
No. Even for a regular sale transaction, there's never been a time in which if someone delays 6 hours, 1 day, that there's ever been liability. There is not. That is undisputed. There is no liability for waiting a few hours.
But would it made a hill of beans a difference? I mean, he was lying to the advisor about what he wanted to do. He was told there would be significant tax consequences, and he did it anyway.
He was not told a lot of things. He was not told to not do the transaction. He was not told that this is...
How can they tell him not to do the transaction? Doesn't he have the right? I mean, don't I have the right to take my money out, even if it's stupid, and put it in something?
No, but your financial advisor should, chief, should let you know that it's stupid, should advise you to try to get you out of, to try to detect whether you do have diminished capacity, to try to get you out of that trance, and to advise you of this. It doesn't mean that you give up.
So, Mr. Hepler, your argument really focuses on the reasons why you think Carr should have done something more. In 25 words or less, tell me specifically what steps, what specific acts or specific statements you think Carr should have made to Mr. MacMillan. In other words, what is the holding in the case going to be? I mean,
it's a couple different questions, but I'll tell you, I can't do it in 25, but he should ask questions, go to compliance, contact the trusted contacts, and put a hold on the transaction for a day or so.
Is the holding you're asking us to make limited to a circumstance where a financial advisor is advising a client that he knows is under diminished capacity? Are you asking us to make, I'm trying to understand what you want the rule of law to be here. Is it specifically directed at clients with diminished capacity?
Well, the diminished capacity is hand in glove with elder financial abuse, and they have the same warning signs. And there was tons of warning signs and red flags for both diminished capacity and for elder financial abuse. So there was
So do you
all
want
of
us to
them.
say if there's diminished capacity, it's an elder, then this standard of care will apply? Are you asking us to create an across-the-board?
No, I think it's a fiduciary duty in all situations. And that fiduciary duty then is to, part and parcel of it, to be asking questions and trying to protect the
So
client.
the diminished capacity doesn't create a greater standard?
Well, perhaps what they should be doing is going to be changing once they detect the diminished capacity. Once they then start not getting good answers to their questions, then that's going to, then what they should do under those circumstances is necessarily going to change.
So, Mr.
It's whether
Hepler,
they
finish your answer. I got
It's
a
whether
question.
they should be, contacting the trusted contacts, whether they should be, contacting, as well, contacting the compliance.
So,
and
Mr.
putting a hold on the transaction.
Let's say we decide the case the way you propose, that there's going to be this expanded duty of care that is imposed on financial advisors. What's going to happen next? The next thing will be that the engagement letters, the client contracts will be amended to exclude this type of situation from any responsibility that the financial advisor has. Then this situation will arise. Are you going to be making an argument at that point that the disclaimer of liability is void as against public policy?
Well, one thing, I don't think, I'm not asking for an expansion at all. I think it's already, I'm just saying what the financial advisors are already saying is their duty, is that's what the law should be, what they're already saying that they have the duty to try to detect.
If the financial advisor, if the RM Davises of the world modify their agreements so that this type of claim will be specifically excluded, are you going to be making an argument that the contract is void as against public policy?
I'm not sure. I'm not sure. That's going to be another argument for another day. But I certainly think that they.
So if it's that unclear whether public policy would or would not be violated, why should we be compelled to enhance the scope of the financial advisor's
I'm
duty?
not sure if someone can waive the fiduciary duties that are owed to them. So maybe it is against public policy. I'm not really sure that those types of duties could be waived in this case. But perhaps I'm not. That's going to be for another day, Your Honor.
Thank you.
Thank you.
On the nose. Attorney Widener?
Good afternoon, Your Honors. This court should affirm summary judgment in favor of RM Davis. The business court correctly concluded that RM Davis did not have a fiduciary duty to conduct an undefined investigation into the instructions that Mr. MacMillan was himself giving over the phone. It also correctly concluded that Mr. MacMillan had actual authority to direct the liquidation of Linda MacMillan's IRA. Now, Attorney Hepler started by saying there are a lot of facts in this case, but the scope of a fiduciary duty is a question of law, and that is why we are here on summary judgment. An investment advisor has a fiduciary duty to invest its client's money wisely and to provide disinterested advice. An investment advisor does not have a fiduciary duty to prevent its client from making his own poor decisions about what to do with his own money. And that is particularly true where the client intentionally misleads the investment advisor about what he is going to do with his money. And that's also a distinction from the story that Attorney Hepler started out with, saying that he was very transparent with the Bank of America. That's not the facts here on this record. Now, with regard to the MacMillan's arguments, some of which rely on misstatements of the record, RM Davis has always acknowledged in this case that it does take steps to mitigate against fraud. But as the business court concluded, that does not impose on RM Davis a fiduciary duty to, in fact, prevent clients from falling victim to fraud on their own. And if it did, reasonable actors would be discouraged from taking steps to protect against fraud. And that policy reason is a good reason alone for this court to decline to adopt the expansive duty that the MacMillans asked this court to adopt in this case. Now, another reason that this court should decline.
Greens on. You do agree there's a fiduciary duty here?
Yes, Your Honor. R.M. Davis has always acknowledged that it had a fiduciary relationship with the MacMillans.
And if the relationship between the advisor and the client establishes that the client has a diminished capacity, does that create an enhanced duty upon the part of the fiduciary into observing and advising the client in those circumstances?
There's no fiduciary duty that's unique to diminished capacity. And I don't believe the MacMillans have developed an argument that there is in this case.
If there was, then if you're correct on that, then the advisor can simply watch their diminished capacity client walk off a financial bridge and into the bay.
Well, that's not necessarily what I mean to imply, Your Honor. In terms of the fiduciary duty that's owed to its clients, for an investment advisor, it arises in the context of providing investment advice. Now, if a client, gives concern for diminished capacity, which here on the record, there's no evidence that there was that concern. So setting that aside for a moment, but if that were the case, then an investment advisor does have, tools at its disposal to an extent. It could make a judgment call to decline to follow the client's instructions, but in doing so, it would take on the risk of not going forward with the client's instructions because, to go back to Justice Connor's question, there is no authority for an investment advisor to decline to follow a client's instructions, and an investment advisor has no way of knowing to a legal certainty that a client is incompetent.
They wouldn't know that, but all these arrangements, well, I think most of these arrangements have trusted contact provisions in them. In other words, if the advisor sees something funny going on, they can call somebody else, a family member, to say, is dad okay here? He asked me to invest in a blimp company. So obviously there's some implicit duty there because of that arrangement that the advisor at some point should call the trusted contact if they had some concerns. Is that an enhanced duty?
It's not an enhanced duty, and it's also not an implicit duty. R.M. Davis has a trusted contact policy and voluntarily chooses to do that. Now, the fact that it doesn't create an implicit duty is especially something that can be seen when you look at the laws that are arising in this area, which are providing immunity for making a report to a third party, but not mandating that action. R.M. Davis outlined that in footnote 27 of its brief. And so the fact that these laws are creating immunity shows that it's not a duty, it's not creating an affirmative obligation, but it is a step that R.M. Davis has taken to mitigate against fraud, and as the business court concluded, it didn't create a duty by doing that.
Well, some of this, nope,
Go ahead.
I'll defer.
Well, I'll jump in. What the heck? You're so sharp. Can I go to the issue of the liquidation of Linda's IRA? What is the basis? Are you saying that there was actual authority or apparent authority for Bruce to act? I mean, you agree there was no instruction from Linda, correct?
There is no instruction in the record, Your Honor.
Okay. So what we have in the record is that Bruce instructed them to liquidate that IRA. I mean, do you agree that that's what the record supports?
Yes, the record supports, as the business court also found, that Mr. MacMillan had actual authority to direct the liquidation.
Okay, but actual authority requires evidence that it was delegated by the principal. What is the evidence in the record that says that? I know that there's plenty of evidence where he says, I can do it. I'm the person who does the finances in this family. But that doesn't mean she agrees that that's the case. That's his perception. Doesn't there have to be evidence of what, either for actual authority or apparent authority, that was her delegation of authority?
There doesn't need to be that evidence, Your Honor, and Mr. MacMillan testified not only to his belief, but also to what Linda MacMillan did. He was asked quite clearly during his deposition, and some of those quotes, although there's more, are excerpted in the business court's order granting summary judgment, but he was asked directly whether Linda MacMillan gave him permission to manage the household finances and to make financial transactions on her behalf.
There's a bit of a wrinkle in your analysis. I mean, there's evidence that Mr. Carr did not believe that Bruce had the authority to liquidate Linda's IRA, right? If there were actual authority, either express authority or implied authority, but if Mr. Carr didn't believe that that authority exists, where does that leave you?
That would be a wrinkle if R.M. Davis was relying on apparent authority. R.M. Davis
So if there were actual authority, but Mr. Carr denied that, there's the authority would, the actual authority would still sort of trump his perceptions.
That's correct, Your Honor. I mean, the inquiry as to actual authority goes to the principal and the agent and the perception that the agent has. The belief of the third party, which in this, as to the authority analysis, is R.M. Davis, doesn't come into play.
And I understand that Mr. Carr is contending, I mean, his version of the February 9th call is that Linda was part of that call and she gave him the authority directly. So I understand sort of the nuance on that issue.
That's correct, Your Honor, and R.M. Davis accepted for the purpose of its second motion that she was not on the call.
It's a dispute, yeah.
That's right.
Can we go back to the scope of the duty? You've acknowledged that there's at least a duty to provide disinterested investment advice, I think is how you described it. Is that correct?
Correct, Your Honor.
Right. What does that mean exactly? So for instance, is that, you have a client who says, I want to move my assets from security X to security Y, and R.M. Davis, says, I think this is a good idea, or I think it's a bad idea, and here's why. That would be covered, right, under the duty?
In terms of, it would be covered, I think, in the sense that that would be the investment advisor rendering investment advice, which here there was no investment advice given.
So that's my question. So is your position that when there's a request just to liquidate the assets, that's essentially not a request for investment advice? Is that why this is not covered under the sort of fiduciary duty to provide good advice to your client?
It's one of the many reasons. Mr. MacMillan was not requesting investment advice. He directed R.M. Davis as its agent to liquidate the MacMillan's investments. And the record shows that when Mr. Carr asked what the money was being used for, Mr. MacMillan intentionally misled R.M. Davis by saying it was for a real estate investment, and then when asked, would you like to share with me more about that, he declined to share any details. So there was no investment advice rendered.
Is it outside the scope of the duty because it was a request to liquidate, or because it was a direction, or both, as opposed to a request for advice?
It's outside the scope of an investment advisor's fiduciary duty in the sense that R.M. Davis was receiving directions from a client as the client's agent, and R.M. Davis was acting as a directed agent, and it's obligated to do that. And
so it doesn't turn on the liquidation versus, move it to, I want to invest here as opposed to here. Can you move it to this security? You're saying R.M. Davis has no obligation in that instance to say, that's a bad choice. If they're directed to do it, they just have to do it.
Well, if the if the client is not asking for advice, which here the client was not, then yes, that we are saying that RM Davis has an obligation to comply with a client's instructions because it's the client's money. And if RM Davis did not act on those instructions and, the client suffered losses during the delay, then RM Davis could face liability. I think it was, pointed out in the earlier half of this argument that there could be a lawsuit because they did not act quickly enough.
Although the agreement with MacMillan specifically says that they may be required when it's oral instructions to confirm it in writing, which at least is by letter, email, or telefax. That didn't happen here, right?
There was no confirmation in writing. However, there was confirmation over the telephone. It's undisputed that Mr. MacMillan initially called and spoke.
I understand. There was a conversation that said, do this. But under your agreement with trading instructions, if it is oral, the company has the right to request it be in writing. And isn't that really a way of sort of making sure that the instruction is really meant and not ill-advised? Isn't that just yet another tool?
It could be. Yeah, and as Your Honor has pointed out, the language in the contract does not obligate getting any written instruction. Here, there was a phone call to confirm, which didn't necessarily need to happen. And so the phone call was confirming the oral instructions and knowing that this indeed is the client that I'm speaking with who's directing me to make this transaction. Now, just briefly, one other piece of the MacMillan's argument that came up in the earlier half of this argument was the issue of diminished capacity. And there is no evidence in the record apart from Mr. MacMillan's own unsupported assertion that he was suffering from diminished capacity. Diminished capacity is not an issue in this case.
Well, I think the argument is that this is such an unusual transaction, really out of the norm for the way the MacMillans had been handling their money. I mean, they didn't want to pay off their mortgage. I mean, they had certain strategies involved, and this was a real departure and deviation from that. So I think the plaintiff's argument is that even though there may not have been direct evidence of cognitive problems, I mean, the conduct involved in these transactions was a red flag. I think that was the way it was characterized.
Your Honor, I think that is a characterization of the plaintiff's argument, but it's a circular argument that, because the plaintiff fell victim to this fraud, that therefore RM Davis should have known about diminished capacity, because the inquiry is, what did RM Davis know?
Right, they didn't know about the fraud, but they did know that this was a very unusual financial decision that Bruce was making. And so that would be the tip-off that there was something wrong.
I see that my time is
Nancy.
concluded, so I'll just briefly answer. As already stated, even despite knowing that it's unusual, that wouldn't create the fiduciary duty to do something about it for all of the reasons that are already stated, and it's outlined in our brief. Thank you.
Thank you. Attorney Hepler?
RM Davis admits that they have a duty to mitigate against the fraud, and yet they didn't do anything. The biggest way to mitigate against the fraud is to know your client. RM Davis is,
And do what?
said
I mean,
that.
I guess
Sure.
that's what I'm really, you say is to know your client.
Correct.
Okay, great. And do what? I mean,
Right.
doesn't he have the right to make essentially bad decisions?
He does, but give him a chance to go through the 4 steps of trying to fix this. The reason that they have these 4 things of trying to help someone when they're exhibiting signs of elder financial abuse or diminished capacity is because they work. They work, and they're finding this. The New York Times did an article over the weekend of how banks are being able to do this. These steps work. When you go and ask questions, when you contact the trusted contacts, when you hit pause on it, when you ask more questions. He didn't even ask any questions. George Carr admitted with the second transaction. Remember this was a crazy transaction. Our expert calls it financially insane. They've never seen it before. 3 different people at RM Davis said they've never seen this before, just lighting their money on fire like this. Nobody would ever do this unless there was elder financial abuse or diminished capacity. Yet he didn't push back at all. He didn't ask any questions. He didn't say, hold on, maybe I should talk to the other account holder here. He didn't do anything in this case. They didn't take any steps. They say that they are supposed to mitigate against diminished capacity or elder financial abuse, but they didn't do anything. They truly did not do anything. And that just cannot be the law. We can't be going backwards on this and say that's fine. When you have a fiduciary obligation, you don't have to do anything. You don't have to ask any questions. That certainly cannot be the standard that this court allows in this jurisdiction.
So, Mr. Hepler, in terms of authority to support your position, in your brief, you really focused on this arbitration decision that was issued by a three-arbitrator panel. Since you filed the brief, have you become aware of any other authority, particularly actually court cases, which support your view?
No, just all the witnesses. I saw one other arbitration that supports my view. I haven't seen anything that's against my view. I haven't seen any articles on it. There's tons of articles that support my view as well. And all the witnesses also say that they have a duty to know their client. They have a duty to look for the signs, the duty to look for elder financial abuse, the duty to look for diminished capacity. We're not asking for this court to make a big step here at all. We're simply asking what these witnesses say, just to underscore that and say, okay, that's the law. What they're already saying that they have a duty to look for. It's already the standard in the financial community to look for these things, to know your client. He did not know his client at all. How could this not be a surprise to him? How could he not see all the red flags? It was absolutely jaw-dropping. This is not a subtle case here at all. This is a very extreme case of showing all the signs of elder financial abuse.
Thank you, counsel. Thank you for your argument here this afternoon, counsel. As is our usual practice, we will be taking the matter under advisement, issuing a written decision in due course. I also understand, Attorney Widener, this is your first appearance on that side of the bench in this court. And as is our custom, we would invite counsel to come back into the conference area and take the greetings of the court.